Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us live today will have the opportunity to ask questions and interact with our speaker. So please take advantage of that opportunity by typing your comments and questions into the comment section below so that we can address them. Episodes are released each week following the live broadcast, so be sure to hit that subscribe button and click the alerts icon so you don't miss an episode. Today, we have Dino Tangredi with us to talk about a case result. Now, Dino practiced personal injury law in Watertown, Mass., and I just found out right before we went live today that he is a fellow New England law grad. If anybody else out there went to New England law, post it in the comments. We love that place and we credit it with the grit and the drive that we have today. I love that we have guests from all over the country. East Coast, West Coast, Midwest, North and South. This method works everywhere, from jurisdictions with unlimited attorney-led voir dire to jurisdictions with no attorney-led voir dire. What I love about this trial result in particular is it is a straight up, solid, six-figure result in a hard-fought case. These are the cases we all see in our practices. It's not as common to see an 8 or 9-figure case. I've never seen one in my practice, not yet anyways. And the significance of that is the EDGE method is not out of touch. It is for all cases because it is about the rule of law and it is about justice. As always, we will put Dino's contact information in the description below, so you can contact him with any questions you have about his case or anything EDGE. All right, Dino, tell us all about how you used EDGE techniques to achieve justice for your client.
Thank you, Jenna. I appreciate that. And well, we did go to the same law school. You could tell many different years apart.
I don't know. I'm pretty gray. Look at that. Look at that.
Oh. So again, thank you, Jenna. This trial that I'd like to talk about and share with everyone had to do with, it's called a slip and fall premises case.
Tough ones.
It was the second jury verdict I've had in the last 7 months, and I'll call them EDGE verdicts. The first one, being last fall, was a federal court case, a wrongful death tractor trailer case. And that resulted in a 7-figure verdict in federal court. This case, the slip and fall, was a slip and fall on ice and snow in Massachusetts. And we tried the case in state court. And I do have a few things to share with people, sharing my screen.
I imagine you get a lot of negative attribution on that sort of a thing in a place that's quite familiar with ice and snow.
So, you're absolutely right. And negative attribution
there it is on the screen. I didn't even know that, folks.
Is my first slide. Jenna, having come to school here, knows that in New England, well, this is what happens. And I understand most of the country's in a heat wave, so maybe this will cool some of you down a little bit. But this is a very common scene in Boston, in New England, in the winter. This is how you get to meet your neighbors. You come out and those are cars on the side of the road. You have fun digging your car out. And these are jurors walking to the courthouse to sit in on one of our cases, a slip and fall. These aren't actual jurors.
Oh, I thought, wow, that's coincidence.
This is how they have to come in the wintertime. So the negative attribution, really, although we know the point of view is with a citizen, a customer of a store, the negative attribution is, look, this is how we got to deal with things 4 or 5 months out of the year. And snow is slippery and you can fall and you got to be careful. And essentially, that was the defense in this particular case. They had put all their eggs in the liability basket. It involved a man who slipped and fell on some ice and snow coming out of a bank, a commercial bank. And he fell and tore his right quadricep muscle. It required surgery to repair. Unfortunately for us, he had had that same injury 20 years earlier. Same knee, same injury. And the defense didn't really fight the medicine. They fought liability because of what you're seeing on your screen. These are hard cases. I've lost these cases in New England in the past, but not since I've been attending EDGE and the courses. It has really, really helped me refine cases like this and get the edge and get justice for our clients. So we certainly had this to deal with. But as I think the motto of the EDGE, Amat Victoria Corum, victory loves the prepared, something like that. I also follow the Sun Tzu, every battle is won before it's ever fought. And it's all about preparation. And the amount of preparation that went into this case was tremendous. From intake to focus groups, to just wearing out the shoe leather, chasing things down, people down, trying to work the case to get the best result possible for the client. The bank where my client was injured was insured by Travelers Insurance Company. Typical insurance defense, black hats on the other side, no imagination, nothing to look at here, keep moving. It's just somebody fell on snow because they're a little bit heavy, kind of a defense. The beauty of doing what we do, you know what they're going to do before they do it. They're not very imaginative. But this was the first time I've ever had a defense lawyer choose not to challenge the medicine and put all his eggs in the liability basket.
That's really interesting. What about this case, as far as case selection criteria or anything else, made you want to take it on, knowing you lost them in the past and they're difficult cases in your area?
Well, it was a referral from some other lawyers, great lawyers. But the fall happened where they happened to do their banking, their business banking. And they had they saw it as a potential conflict of interest, and they asked me to represent the injured gentleman. I was flattered. This is a great law firm that does tremendous work and follows the EDGE principles as well. So I was quite flattered that they asked me to get involved, and and then they were helpful throughout the case. Very often, collaboration. In fact, towards trial, I was having a little difficulty with some phrasing, and some EDGE lawyers really just tweaked it enough to give it the extra that it needed to really send it home. I was almost there, and then collaborating with other EDGE lawyers in Massachusetts really nailed it.
Right.
So this is exactly where he fell as he was coming out. And the client took this photograph while he was getting into the ambulance. If you look at the reflection in the window, you can see the ambulance there. Now, this picture turned out to be a point of contention for quite some time, because the time of the fall was a big part of the defense. the defense wanted to know exactly what time this photograph was taken. And we couldn't tell them. We gave them a range. But in my mind, they could have pinpointed this down to probably within seconds, because it's a bank and they have cameras everywhere. And this customer, this gentleman who fell, was just inside. So although they were pushing us an awful lot for the exact time of this photograph, when I pointed out, well, you know, the ambulance was there, so we can narrow it down to a few minutes. The ambulance report is pretty well timed. And they were like, oh, there's an ambulance there. They didn't even notice it.
What was their hang up on that? Were they like trying to call into question some credibility issues or something?
Well, so the defense essentially was, it had only just started snowing. It hadn't been snowing for very long. Look, there's not much on the ground. And if he fell even 10 minutes before this, there would even be less. So
but as we all know, if you've handled a snow and ice case like this, de-icer has to be down before the snow happens.
Well, our focus groups love pre-treating, right? We learned pre-treating. Everybody knew about it. Nobody, you know, it wasn't a foreign concept to anybody. And when we deposed the person from the bank who runs all their properties, he's just, pre-treating doesn't work. It's just not a good concept. And I was just, good. You just say it, because it's like being clairvoyant when you have focus groups. Oh, that jury ain't going to believe that crap.
Absolutely. Excellent.
So when he dug himself in, I just, okay, you know, tell us why. And it just didn't matter. Nobody was going to believe him. So pre-treating, yes, it turned out to be a part of our case in this one. Let's see. So we had a safety rule, of course, and the safety rule, it was great at the deposition. Of course, he agreed with it. The facilities director of the bank agreed with it. So then tried to see how far we could go with it, and said, do you think a customer of your bank should expect a safe entry? Yeah, they should. Okay. Well, do you think they deserve a safe entry? Yeah, they deserve one. And I'm like, okay, I got it. Keep going. I don't know. Do I stop?
Is it a right?
Do they have a right? And he said, oh, of course they do. And I was just, okay, that one, check that one off, right? Not knowing really the harm he was causing, I don't think. So this bank is a branch. There's 32 branches throughout Massachusetts. And the deponent for the bank was the man in charge of maintaining all their 32 properties. And one of the things we got into was our bumper sticker. And we talked about, before we showed him the bumper sticker or asked him to agree to it, we said, does getting the weather forecast play any role in how you maintain the facilities, your 32 banks? Yeah. Well, how? He says, well, if it's hot in the summer, we got to know there's going to be more need for air conditioning, so we prepare. Okay, and if it's going to be cold in the winter, we've got to prepare for heat, and we got to be ready for snow. Okay, so do you get the weather every day? Yes, we get the weather. He goes, I get the weather every day. He goes, and the weather can change from some of our branches to others, so I get many different reports. I said, it's important, right? Yeah, it's important. So we can prepare properly, he says. Okay, so did you get the weather on the day of Mr. Freeman's fall? Oh, yeah. What was the weather forecast? Well, they said it was going to start snowing about noon. My client fell at about 2. Okay. So now that you knew it was going to snow, what's the plan? What do you do? Wait for our snowplow people to come. Okay. Anything else? Nope. We had gotten the contract with the snowplow contractor. They got $222,000 a year for about 6 months when it could snow in New England. $222,000 to plow, salt, and shovel 32 branches. They got that price if it never snowed in the winter or if it snowed every day in the winter. That was the kind of gamble, the arrangement they had. And the snowplow contractor was called Einstein. And there was a good pun in closing using Einstein. You don't have to be Einstein to know. And you know, if the jury laughs, you're doing all right.
Mm-hmm. Absolutely.
I make it a point. I don't try humor in cases at all. That one just kind of came out.
Oh, I'm glad it landed well for you.
So was I. But it really worked into one of the theories of our case. One of the themes is the weather forecast. It was part of our voir dire in this case. And voir dire is relatively new in Massachusetts. It's only been here about 4 years. And for 2 years, we haven't been trying cases because of COVID. So it was about a year of it where everybody was trying to get a handle on it, then a sabbatical from it, and now we're back at it. So one of the voir dire questions I asked was, who pays attention to the weather forecast? And weather is the biggest thing. It gets the most time in the half hour of news at night. People love weather. I don't get it, but they love it. They want to know about it all the time. So everybody's hand goes up. Yeah. Why do you get the weather? You know, we go through the veneer. Why do you watch the weather? Oh, helps me plan. Tells me how much longer I need to get to work. It tells me I got to go out and shovel. Maybe I'll pre-treat. I mean, we got all the answers we needed from that in voir dire. So we knew people watch the weather to help them prepare properly. So if it's predictable, it's preventable, kind of circled back in with all of our other work from the beginning in voir dire to the end in closing. The symphony connected the dots the whole way. So I love spreading the tentacles when I can. We established that these 32 branches, they just don't have banker's hours. Banker's hours was a thing years ago. They had great hours. They were hardly ever open, 9 to 3 or something, 5 days a week. But now these banks were all accessible 24 hours a day, 7 days a week, 365 days a year. So, you know, I got the man from the bank to admit people go to the bank at 2 o'clock in the morning. They use the drive-through. He also acknowledged that people park and walk into the vestibule to use the ATMs. So 24 hours a day, whenever there's a hazard like snow, could have an effect on people. And he acknowledged that. This bank has 60,000 customers. Some of them are disabled, some are older, some are young, but each and every branch has at least 2 handicapped parking spots up close. Spreading tentacles. The facilities budget for the 32 branches was $3 million, which came out to about $93,000 per branch. That was another number that went up on the flip chart, 93,000, 3 million went up there, 60,000, anytime there was a number, it went up somewhere. It was a big sheet with numbers all over it. Mm-hmm. we established that the bank itself has no written policy in writing about how to prepare for snow in New England. Nothing. And they have no training that they give their branch people. All they wanted to do was point the finger at their snowplow contractor and, hey, it's snow. So their plan was we hire a snowplow contractor. So, as they say, the money shot. Let's see. This is the man from the bank. And let's see, Jenna, will you just raise your hand when I hit play to let me know if you can hear it? Thanks.
So in that period of time from when the snow starts until the arrival of Einstein, snow is going to accumulate in the parking lot and on the walkways, correct? Correct. And if the bank is open for customer walk-in business, customers will have to walk through snow and or ice to get into the bank, right? Yes. Okay. And snow and ice can be slippery for customers? Oh, yeah, that's a good. And slippery can be dangerous, right? Yes. All right. What plan does Middlesex Savings Bank have in place for this time zone that snow accumulates until Einstein gets there?
The plan, well, if it becomes slippery and dangerous, the branch itself would either by it being reported to them or by them noticing it, would put in a call to the facility support line here, and our maintenance team would take care of it.
Okay.
So this was actually played in the opening. And this was the deposition, of course. And you could sense it was a little awkward. I was feeling my way as we went. But I asked that same series of questions when he was on the stand a little smoother and gave the same answers. The awkward part was what I called in the deposition the zone of time between when the snow starts and when Einstein can get there. This is what my friends helped me refine to calling it a dangerous gap in time.
Okay.
Subtle change, same idea. We're dealing with this period, but the word dangerous gap in time, just I said it as much as I could. And he agreed it was he was calling it a dangerous gap in time.
Oh, wow.
And there's no plan. We also learned that each branch is given snow melt and the shovel, but nobody's given any instructions on how to use it, when to use it, where to use it, what to do. It's there, but there's no training. It's wait for Einstein to come. They'll take care of it. So there's this dangerous gap in time which threatens anyone going in and out of the bank. Let's see. And what we did is, I love checklists.
There you go. Nice.
It's just, especially when you know how it's going to go. 10 questions here. Even the one that answers yes is a good one for us. Do you get the snow weather forecast ahead of time? Yes, we do. Okay, then the rest. Do you pre-treat? No. You got a written plan or policy? No. Boom, 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 boom. People watching the trial just said, oh, it just kept getting worse and worse. Did you
get this straight from the 30B6?
Yes.
All right. So you went through the checklist with him at trial, and he gave you those red check marks.
I think his lawyer told him, reread your deposition, stick to the script, don't come off. And this guy was, I led him around. He was the first witness. It was over. He was so productive for our case. I think I canceled about 5 witnesses because I'm learning I tend to over-try a case. And I said, why? I got it. Let's go to damages.
Awesome.
So with all these check marks, we'd go through items like this. You could have used iced melt. You could have used a shovel, your cones, a warning cone, right? And then we found this great one here on the end. I said, you could have closed the bank to the walk-in customers and just use the drive-through until Einstein comes and makes it safe. He says, oh, yeah, we've done that. Yeah. So he just kept digging deeper and deeper.
That's awesome.
Is there anything you want to talk about, Jenna? I'm sorry. I can.
Oh, no, go ahead. I'm just listening, and like I actually just texted Young G some thoughts based on what I like doing these podcasts because it gives me so much awesome ideas and reminders about things. One thing actually that's interesting, Dino, that folks, I don't know if we've talked about this in a podcast yet, but you had the 30B6 witness go first, yes?
Number one.
Share with us about that. What's the mindset? What's the thinking? Why? What's the risk there? What about if defense cross-examines them and they undo everything you just tried to do?
If so, the deposition course, probably my second favorite course of all. You do it right. Again, you prepare properly ahead. You do the work. And you get them and you videotape it, and you got to videotape every one of them. You get what you want. You control the deposition. You get what you need, and no more, no less. And then again, the defense lawyer is going to tell them, stick to the script. Don't go off court, off the depot. So you already got them once. They're scared to death. I mean, I bet you this guy never said more than yes or no. Might ask them a couple of why questions that couldn't have hurt me in any way. But he wasn't humanized to the jury. He was an automaton, just yep. And jury's just doing this tennis match, You bring out the checklist just to break it up a little bit. And, I gotta get a better marker. It needs to be thicker and bigger. This one I thought was okay, but I like to have it even bigger. Sometimes I struggle with a check versus an X, but either way, you get your point across.
So are you guys in person then? It looks like a poster board there. That
I'm sorry, what's the question, Jenna?
Oh, so are your trials in person then? We're all virtual over here, but that looks like a poster board. So
yes, this was in April, just this past April. And the one in federal court was in October, and that was in person.
Nice.
And the federal court case, we had to wear masks. In April, in state court, no masks. Okay. So yes, we had this. And this is probably as tall as I am, about 6 feet tall, this board. Cost about $100 at Staples. It can be dry. You can wipe that off if you have to very easily. I've done a few trials with checklists. It's a ball.
I've got to be able to successfully utilize them. We're working on it, and we've got a couple good ones for a trial we have next month. So I'm hoping we'll be able to do it. But yeah, we got to be able to really get that in there without judges yelling at me and everything else. So
when it came to damages, we freely acknowledged that my client had torn this quadricep muscle 20 years earlier. We brought that out. And, but we also talked about all the things he's done in the last 20 years on this bad knee: golf, hikes, trips to Europe. It really didn't slow him down. We had him examined by a Harvard-educated, board-certified orthopedic surgeon who did an examination and wrote a report. And in Massachusetts, we can submit a report if it's sworn to under the pains and penalties of perjury and you satisfy a couple of other requirements of the law. So we had this report. And in the past, I've read the reports to juries. Sometimes if I thought I was getting real creative, I'd have somebody else read it, another lawyer, or just bring somebody in.
Okay.
A few years ago, I decided to, if the report was important, and they usually are, I hire a professional voice actor to come in. They're not hard to find. You Google it. They're always looking for work. Go to your local radio station. They're there. I got a guy. He does the U.S. Open. He's been doing it for 20 years in New York. He does monster truck stuff. His voice is amazing. It's so amazing. You know, I figure, okay, he's going to read for 20 minutes, 15 minutes here. I can do some other stuff, and you know, I got to pretend I'm listening. But you sit there and you're like, wow, what? The jury is, wow. The judge, when he finished, leaned down and said, "Sir, you got a hell of a set of pipes."
Wow.
It's such a soothing voice. It's such a professional voice. You know, his inflections, his deflection, all of his flexions are unbelievable.
All flexions. This is what I dream of. I have the worst voice, and I wish I had a good voice, because I feel like half the time I'm rubbing the jury the wrong way just by speaking. And I've tried, and it's very, very difficult. I mean, that is such a blessing. It really, really is.
It's amazing. I've used them twice, and after this last trial, he called me up to find out how it went. I said, "Oh, great!" And we ended up getting together for a burger and a beer. And what a great guy! What a history! But don't be afraid to do it. And I think it cost me $150.
Wow.
You know, so don't be afraid to try it.
That's really great advice. Be creative, right, folks? Like, do something a little bit different. Do what you know is going to get your case where it needs to be. I mean, in whatever your jurisdiction may be, whether it's you have the opportunity to have somebody read something, or whether you have, you know, a way to bring in something really interesting and dynamic to your jury, do it, because they're bored out of their freaking minds, man. I mean, I'm bored in trial half the time.
I agree. Anytime I don't have to talk, which is why I put together a PowerPoint, it's just right. Let you see it.
Yeah.
So that was that. Let's see. Before I forget, I want to make sure I get this in, because I got in big trouble for doing this. So in my closing, around here in New England, most people have this near their doors in their homes. And inside, they put salt or sand, because in the winter, you got to salt or sand your stoop, your walkway, your sidewalk in front of your house. And it's pretty common to see this even in stores. And in my closing, I had said, you know, how much would it cost just to drop a little salt out there for people? And I sprinkled it on the floor in front of the jury, on the carpet in front of the jury box. Well, I didn't think it was that big of a deal. And the judge, God bless him, I guess I had a couple of people watching in the gallery, and they said the judge looked at the defense counsel when I did it, like, "Are you going to do something about this?" And defense counsel was just doodling or something. And then the judge looked at my friends, the lawyers in the courtroom, like, "Did he really just do that?" This is all going on behind my back. I just thought it was okay. And, you know, the jurors smiled at me. And but after the jury was dismissed, boy, the judge really gave it to me. I'm glad he waited. But I still, to this day, don't understand. You know, I was almost,
was it the talking about the cost thing? Like sometimes, what is it? Subsequent remedial measures or well, I don't know.
no, it was, I dirtied his carpet, his floor,
No, no.
in his courtroom. Now, he's yelling at me, it's all over. I figure when he said his courtroom, I knew where I could go with that. Judge, it ain't your courtroom. You're just a tenant. I didn't go near. I said, Judge, I brought a vacuum. I was prepared. Don't worry, you won't see a thing. But we just sprinkled it and it floated down very nicely. And
Wow.
but again, I got in trouble with it.
That's something to keep in mind too. Make sure but it's interesting that he looked at defense counsel to be like, are you going to say something about this? My carpet.
Yeah, you should have asked permission before you defiled my courtroom.
Oh my goodness.
So that was okay. I don't mind.
Hey, we have a question from the audience here. Peter
Uh-huh.
Levine asks, can you please repeat what the professional voice actor read? Yeah, so how did you use them? What did he read? This is kind of a unique thing, it sounds like, in Massachusetts. So share with us.
So we had a nice narrative report, about 4 pages, from a qualified doctor. And the report listed all the items that the doctor had reviewed. That's all the medical records, all the x-rays, the surgical notes, all the medical related to the fall, all the diagnostic tests. So the doctor listed everything he reviewed. Then the doctor talked about how he looked at the records from the quadricep tear from 20 years ago, and he looked at all of those films and all that stuff. Now, we had to give the doctor all this stuff. And then the doctor talks about his examination of the client. I have to send the client to the doctor. It's essentially an IME, right? But it's a real one because he's a board-certified orthopedic surgeon who's not an insurance whore. He doesn't do this for a living. He operates for a living. But I've developed a relationship with him, and in cases like this, he's willing to do an IME for, I think it cost us $1,200.
Oh,
So the client goes, he gets examined. Then
the report? $1,200 with the report?
With the report.
Oh, cheap.
Very cheap, very reasonable. And so then he sets out what the injury is. He establishes causation in the report, and then he assigns a permanency rating. So it's 4 pages. It's pretty comprehensive, but boring as hell. But brought to as much life as it can through the voice actor. So the report itself becomes evidence, and the jury gets that. And we don't even have to read it to them. It's in evidence. I can refer to it. I can hold it up and say, I've got a report here. You're going to have as evidence. You can look at it. You could do it that way. I think the most effective way to make sure they hear it and get the information and get it intelligently and in an interesting fashion is a professional reader.
Why don't you bring the doctor in?
Because then he's about $8,000.
Okay. This is really, really interesting because I think every time we have a case, we bring the doctor in, and I've never thought about whether or not we could just use the report. I don't know. In fact, a lot of times we bring a motion in limine that says, don't put the report in because it's got a lot of stuff. But I suppose if you worked with your expert, you could work on what that report might need to look like such that it was just the facts, ma'am, kind of a thing. This is super interesting. I like that.
So the medical records related to this gentleman's fall are probably, a foot thick, right? And what the narrative report from the doctor does is just condense all that, puts it all in one spot.
And of course, the issue doesn't come up because you guys have a rule for it?
That's right. We have a Massachusetts general law. And it came about years ago because it said, we can't have doctors come into court. They need to be doctors. They got to do their doctor thing. If they sign the report under the penalties of perjury, and you have to give it to the other side 10 days before you're going to use it and things. it survives any of the hearsay issues.
Interesting.
And it comes in. Yeah.
Cool.
It's,
We all learned something today. That's fascinating.
I'd be surprised if most states don't have something similar.
Yeah.
And I'm sure if you don't, and you got the doctors involved in the legislation, they would support it like heck.
Well, they would.
And you'd get it passed.
I mean, that's why they charge so much, right? They want it to be cost prohibitive to talk to them and get this stuff done because they don't want to be spending all their time in court.
That's right.
All right. Hopefully, Peter, that answered your question. So basically, the professional voice actor read the report that Dino's medical doctor, Harvard Fancy Pants, had provided. So
They love
cool. Everybody
Harvard.
look at your state's rules and see if there's something like that. That's pretty neat.
They love Harvard around here. Whenever
Yeah,
you can
I know.
raise it. Although I had a new client come in this morning. He works there and he's got a discrimination claim. So, they're not
I can see that.
immune. Right?
Absolutely. Absolutely.
Speaking of medicals, we didn't put in the medical bills. I haven't put medical bills in a case in a long time. And I think our medical bills were about $60,000. The offer on the case went back to before the lawsuit was filed. We presented a claim like we usually do. And I got a claims adjuster on the phone who essentially the call went like this. Yeah, I've looked at your package. Your guy's heavy. I'm going to offer you $50,000. Take it or leave it. If you don't want it, don't ever call me back. I'm not going to change my mind. That's it. Do you want a release? And I simply said, let me think about it. And then sent some letters to set up a consumer protection violation in Massachusetts, then filed the lawsuit and never heard from the adjuster again. Nobody came to the trial. I mean, when she said it's 50 grand, take it or leave it, don't call me back, she meant it.
Well, hey, we appreciate mean what you say and say what you mean around here, but man, that was a bad choice for her.
So we have an unfair claims settlement practice lawsuit going.
Good.
For that, the verdict, by the way, it was $275.
Excellent.
I had asked the jury for $3. I can't figure out how they got to $275, but
They couldn't give you what you wanted. They couldn't give you. They had to discount it a little bit.
that's right. I guess.
I feel like that's just in the mind of jurors. Every focus group I've done on that, they're like, well, you always ask for at least 10 times the amount you want. And I'm like, okay, well, I'm going to keep doing it then because I don't want you to cut me off at the knees when I ask you for the real number.
Yes. I try to make it realistic. I haven't had the courage, I'll call it, to do the voir dire with jurors like, will you, if I ask for a figure, do you think I've inflated it? Or, however that one goes. I've done it with focus groups and I'm not comfortable doing it yet. So voir dire. So because it's new in Massachusetts, relatively new, I had a great judge, a judge who was on the forefront of getting voir dire, attorney-conducted panel voir dire into Massachusetts. He was one of the proponents of it, so I was lucky. However, he has a requirement that you submit all your questions that you're going to ask in panel voir dire to him ahead of time, and at the pretrial, he'll go over them, and the defense lawyer can object and make their arguments against it. And so a week before trial, I submitted 25 voir dire questions. I knew I was only going to use about 5, but let me send defense counsel down some rabbit trails, right? So we get to the passion question, which was in there. And the defense lawyer goes, Judge, I object to this question. And the judge goes, oh, really? Why? And he goes, well, I've just never heard anybody. I've never heard of it before. And the judge goes, I have, and I love it. This is a great question. He goes, it really relaxes the jurors. right? So I wasn't planning on doing the passion question. It wasn't one of the ones I was going to do. Well, my first question was the passion question because the judge liked it.
Gotta
And he's
get
right.
it. When you get a piece of information, use it.
It was, yeah. But I love the objection. I've never heard that before, you know?
I hear that a lot from defense, and it's frustrating because sometimes the judges will be like, yeah, I haven't either. And I'm like, so what? Is there something that says I can't do it? So what? You haven't heard of it, you know? I mean, like that to me is the craziest thing. And it's even crazier when the judge buys it as some sort of legitimate objection. Like, I mean, I can't even count how many times in this past trial I did, both defense counsels said over and over again, this isn't my first rodeo. And I was like, well, just because it's not your first time trying a case and something is being done a little bit differently, it has nothing to do with whether it is acceptable or not. And it's, oof. But yeah, that's, yeah, good job getting that one in.
Yeah, it's hard enough, right?
Yeah.
But so we had a good voir dire, and despite presenting the voir dire passion question properly, the first person, her answer went against the rules. She said, "My passion is to serve God."
Oh.
So, you know, okay, in my head, well, no, here we go, right? Nobody listened. She didn't listen, but okay, and just kind of nod and try to get more. Well, she ends up telling a story about not being able to have children and spending tens of thousands of dollars on fertility treatments, and nothing worked. And she was resigned to the fact that she was going to not have children in her life. And then she asked God to help her get pregnant, and she would devote her life to him. And she ended up having twins, and then another set of twins. So she tells this beautiful story, and I'm like, how can I yell at her for not following the rules?
Oh, that's sweetly. That's like a Ruth story, if anybody has read the Bible before. Ruth was like that.
It was a beautiful story, and she was really a beautiful person, but that set everything else up. Then all the other passions were, nobody could be outdone. Oh. Well, I want to feed the poor and hungry. Everybody wanted to do things for other people. They, you know, even if fishing was their passion, they weren't going to say it now, right?
Oh my God.
So we got all these people who were interested in serving others, which is, you know, pretty good group of folks.
Then they can't go back on that and give a crappy verdict.
That's it. They're all committed to each other, you know.
Did this happen in Worcester?
This happened in Framingham, Massachusetts.
Oh, okay.
And so this is the bank. I'll give you one more little bit of tidbit. Because it was a bank, you know, in the beginning, I said to myself, there's cameras everywhere. They had to capture this guy falling. Let's see if the story he's telling me matches up to the video. So we request the video, and they tell us there's no video of your client falling. There's no camera. So they send us. Well, I say, well, you're going to have to tell me where all your cameras are. So they did, and we use this in the examination of the facilities director. The X here is where my client fell, stepping off the curb. His car was parked in that parking spot. So they have a camera in the front, camera number 1, that captures everything in the front of the bank. Number 2 catches the rear of the bank. It's over here. You got 3, which catches the side, and 4 catches the drive up, and 5 catches the ATM vestibule kind of thing. And so I mark all these and just leave it. That's all the cameras? That's every camera that catches the outside? Yep, that's all we have. Just left it. And in closing, I pull this out. And I just kind of look at it for a minute and see, these are all the cameras for the exterior. And I just kind of look at the jury, and they're looking at the picture. And I'm looking at the jury, and finally, a couple at a time, they start looking at me and smiling. Like, you know, it didn't even have to be said. It's like, you mean to tell me that whole side of the bank is exposed and doesn't have a camera? So I couldn't prove what they said. I just made the inference. You're lying to us. You're lying to this jury. And this is a bank. If it was a bank robbery, they would have had film of everything.
That's a good point.
So it was kind of one of those things, and instead of jumping on them and saying, well, why isn't there a camera over there? And getting some plausible explanation or something, right? I just leave it and bang at it in closing. And I think that went a considerable distance. It was just credibility. They lost the credibility contest with this, I think. Nobody really believed it.
Yeah, that's a good example of the subtlety of this method, right? Which is, I think, who did I talk to about this? Oh gosh, recently we were talking about how subtlety is not our best quality. Gosh, who was it? Anyways, yeah, and that's one thing about this method that is difficult to learn if you are at a ball in a china shop like I am. And I love that you were able to do that here, Dino. That is so cool that you put this photo up. You didn't even have to say anything. Probably if you did say it, it might have been, might have backfired. It might have made you look desperate or, tinfoil hatty. I think that's really neat, and something that everyone listening should keep in mind is that it's not all about slamming things home. It's about letting the jury come to their conclusion.
It's hard to do. It's hard to unlearn some stuff because you're like, oh, I better tell them just in case they can't figure it out. But
you're like, are you getting this, guys? Do you get it? You see what I'm getting at here?
So it's the beauty of focus groups. I think I did 4 on this case. When you know where it's going to go before you even do it in the courtroom, and you know how it's going to be received, it almost feels like cheating.
Mm-hmm.
Almost.
Mm-hmm.
That was that's what I've got.
That's spectacular. That's spectacular. So let me see. Let's see. It looks like, do you have a bunch more slides? Because we got a few minutes left. I have a couple questions. Is there anything else you wanted to show?
I don't know how that got in there. That's part of my office. That
nice.
we negotiated this in a mediation. The billiards room, Liberty Mutual, had to pay a little extra, and I bought that's also where we do focus groups. That billiard table gets covered, and there's a camera in there up on the ceiling, and it captures everything. That's kind of the laboratory.
Awesome.
But gets a lot of pool use too.
Nice. Work-life balance. That's great. Well, when you have fun things at the office, and the tech world has done a great job of this, when you have fun things at the office, people don't want to leave. So they're going to stay longer, right?
That is the truth.
Awesome. There was one thing that you mentioned a couple of times, Dino, that I wanted to touch on with you, is that your client was a little bit overweight. What is the significance of that, and how did you handle it, and the kind of negative attribution people have around weight, especially with slipping and falling and knee injuries? 2 things, slipping and falling and knee injuries.
We put him on a diet before trial. No.
Okay. Oh, I almost really believed you. I was like, that's one way to do it.
It's like teaching your non-English speaking person to speak English, right?
Exactly.
I couldn't do that to the poor guy. He actually gained a few more pounds because he was less active after the knee injury and the surgery. But we showed him. He actually, ironically, sells stair lifts for the home.
Oh, interesting. Okay.
So that for people who have mobility issues in their home, it extends their ability to stay in their homes. And he's a fantastic salesman. He wins all kinds of awards. And the company he works for is from Sweden, and he gets all these trips to Europe. And so we had a lot of photos of him. I wish I had them here, of him all over Europe, in front of beautiful churches or buildings or an Eiffel Tower or whatever. And it suggested that he's not immobile, right? He's not a lazy guy. He's successful at work, right? What's the code for fat? It's kind of lazy, right? Something like that, if I remember. And this was a guy who did things. He went in and out of homes, and he knew how important mobility was to people, and he was facing these issues down in his life in the future. So we showed him as a pretty, at least, active guy traveling, and he now has a handicap sticker for his car, so he can park in handicap spots. And we made sure he brought that in and held it up for the jury. And he didn't want to do that. I made him.
The mobility aspect is huge in these cases. And if you go, I mean, that even goes to the permanence of it, right? It is such a big deal that the government is willing to give me this special pass so that I don't have to walk far because I can't. That's corroboration.
The doctor has to give you the okay to get it.
Yeah.
They don't give them out in Cracker Jacks.
Right.
So
yeah, that's serious.
That's how we addressed it. He's a salesman, so he was pretty energetic. He comes off not as a slimy salesman, but as an assured person who's confident. He's also a Mason, so he does a lot of charity work in his community. He was a good guy, and in fact, he downplayed his injuries too much. I was really trying to pull something out of him, and
that's why you didn't get the 300 right there.
Probably, yeah, he's okay, they said. But he was a pleasure to work with. The offer was $50,000 going in. Nobody attended the trial. Now, my background, I used to be a claims adjuster for about 8 years before when I went to law school.
Wow.
And we used to go to trials all the time. You watch and you adjust. You put money on, you take money off. Depends how it's going. Nobody present.
Oh, that's so interesting. Because we've had adjusters at trial. We've had them there checking out, especially when the plaintiff's on the stand. That's who they care about, right? How did they present? We had a case recently, actually it's the one that's going to trial, but we were just in mediation, and one of the defendants said, we want to meet their risk assessment or risk management person. We want to meet the plaintiff. And we were like, well, why? What's the deal here? He already took his DAP. It was videotaped. Like, what are you looking at? Are you going to try to talk to him and get him to, come off this, or what's your deal? Because Don will share sometimes when it's been an appropriate moment to allow that to happen. But it's not just you want him. Okay, here he is. So it turns out what did they do? They deposed him, took the video recording, but never ordered it. So the risk assessment folks never met him. And just through their own, stupidity, bad choices, whatnot, chose not to show their risk managers the type of person our client was and how he presented. We were like, well, then too bad. Honestly, they came with no money anyways. We did not. Had it been a matter of a few $1,000s or even, a few tens of thousands of dollars, we might have put him over there to put him over the edge. But that's important. And that's really interesting that they chose in your case not to even give him the time of day. Yeah.
But they paid pretty quick.
That's good.
And we're going after them. We're going after them pretty hard for unfair claim settlement practices. And we'll see where it goes. But we got potentially double or triple damages if we're successful. But we'll take a peek under the hood.
Yeah, I mean, keep woodpecking at that stuff, guys. And anybody who has bad faith or unfair claims practices or whatever you have in your jurisdiction, once the verdict is in, don't stop there. Find out what other ways you can, because at the end of the day, what are you doing? It's not just about getting more money. It's about making sure this stupidity doesn't happen again, right? Pay the amount we want up front. Don't drag everybody through this and waste resources, right?
I don't think they're ever going to learn. So
that's the hope. That's the hope, right? I don't know. Sometimes I feel the same way, especially with car crashes, man. I'm like, if I ask a jury to hold these people accountable because then others won't do it, I feel like, what are you talking about? Because people are going to keep doing it.
Yeah, especially the phone stuff, the texting and driving with a phone, that's most people are doing it. So it's hard. But there's ways around that too.
There are. All right, everybody. Thank you, Dino. And thank you to all of you who joined us for this week's episode of Fridays with Keenan's Cutting Edge. If you liked the episode, please click that thumbs up button and fuel the YouTube algorithm. And don't forget to subscribe and sign up for alerts so you don't miss an episode. One thing to keep in mind when we do these case autopsies is a lot of what we discuss with the lawyers who have tried these cases, or even when I did my own autopsy, is very surface level. This is a public podcast. Anybody can listen to it. So we don't discuss things on a very in-depth level. I hope that by sharing and discussing these case results, it gives you a taste of what you can learn when you attend the colleges. Those of you who have attended colleges and listening to these podcasts are getting a lot more out of the episodes than those who have not. And if you take the colleges and then come back and watch some of these podcasts, you'll get even more out of them. Next week, we're going to do a replay of Joe Tunstall's relaxation and mindfulness episodes. We're actually going to do a couple of replay episodes this month while I take some time to enjoy the precisely 8 weeks of unmatched, incredible summer that we see here in the Pacific Northwest. If you want to be on the podcast, or if you want to hear something or see someone on the podcast, don't hesitate to reach out and let me know. I always respond to calls and emails from listeners, and this podcast is for all of you. So let me know what you want to hear. I look forward to getting a nice reminder about the importance of relaxation and mindfulness in this wildly stressful profession this next week with all of you. Have a wonderful weekend, and I'll see you next time.